choose your ride, whether you're the driver, the passenger, or the party host. Thanks for supporting Sober Driving. I hope we never meet.
Visit arrivealive.org to find out more.
Join me over coffee as we delve into topics that affect our everyday lives. And today I'm in conversation with Angela Yenssen, and she is the staff lawyer and a social worker with the Grey Bruce County Legal Clinic. And today our conversation is going to focus on the importance of wills and power of attorney. And we have a lot to talk about. Wow. When I joined in on the seminar at the library that you were presenting on wills and power of attorney, I thought I knew a lot going into it, but I was surprised. So you have a lot of knowledge. So why is it so important that we write a will?
Well, I'm going to start, Mary Jane, by just talking about what a will is, because sometimes people get very confused about that terminology. What is a will? They hear other terms like codicil and power of attorney. That's one of the things that the law tends to do, is create a lot of words and causes a lot of confusion for people. So I'm just going to start by explaining what some of these terms mean, and then I definitely want to talk about why it's so important for everyone to have a will, even if they don't feel like they have a lot of money or possessions. So a will is a document that someone writes and signs that says what they want to have happen with their money and their possessions when they die. That's different from a power of attorney, which is a document someone signs to name someone to make decisions for them if they're not able to make their own decisions while they're still alive due to some sort of illness. And then I mentioned the word codicil, which is a minor change that someone makes to their will. So it's possible to write a will, make a minor change, not have to redo the whole will, and that's called a codicil.
Well, those are technical terminologies for sure, and we rely on your expertise to sort of understand all of this. But as a layperson, when we put our will together, my husband and I, we actually looked at it as being a love letter to our family, because the will is the last memory you have of that person. And sometimes it can really bind families together, and sometimes it separates them. So we wanted it to bring our families together, and so we decided to look at it as a love letter. But I think, you know, once you get into all that legalese, things may look a little different, or it may be interpreted by other people for different reasons.
Yes, a will is a technical legal document, but there are ways to write a will so that the family feels supported and loved as they are reading it. So if the person is adding into the will something like, because I love you, I'm leaving you this favorite piece of jewelry of mine that I know you always enjoyed, and I smile when I think of you wearing it after I'm gone. You can absolutely do those sorts of things even in the midst of a legal and technical document.
Those technicalities are important.
They are. They really are, because there are some automatic things that happen in law that people don't realize when they are writing a will. So, for example, If someone names an individual to inherit an item in their will and they aren't specific about that item. For example, they say, I'm going to leave my daughter Jane my favorite necklace. Well, if you had more than one necklace, you're assuming that everyone has the same understanding of what your favorite necklace was, and they might not. Yeah. So you have to be very specific if you're going to leave items to someone, so it's clear what it is that you're leaving behind. So that's just one example of how you have to be careful in documents to make sure that you meet the technical requirements. It has to, first of all, be specific enough that it's clear what it is you're leaving behind and to whom.
One of the things that I came across, particularly in my career path, I'm retired now, people would say, because wills are important, and I was always encouraging people to write a will, and the comment would be, I don't have anything to leave. Like, I don't have any possessions to leave. And I said, but you have children, young children.
Yes. In a will, people can, in the province of Ontario, name someone to be a temporary guardian for their children. The guardianship lasts for 90 days. What that does is it allows there to be someone with clear authority to make decisions about the well-being of the children, to give time for someone to go to court and make an application to become their guardians. So you know when you die that, well, for 3 months it's clear what's going to happen with the children, and then after that it's up to the court to rule as to who should be the legal guardian once someone has made an application to the court.
I did not know that, because we assumed that the people we named in the will would have our children in perpetuity, you know?
And this is an example of what I said earlier about there are a lot of automatic things in law that people don't know when they sit down and write a will. When they try to do it on their own without legal information or advice, you can end up putting something in a will thinking you've got everything looked after, but in fact, the way the law works, you haven't taken care of everything because you didn't know that you needed to word the will in a different way. Or you didn't know, for example, that the guardianship under the will only lasts for 90 days when you name a guardian for your children. So the expectation would be that the people you want to be the guardian of your children would hopefully go to court and apply to be permanent guardians, but they have the option not to. If you die and you have named them guardians of your children in your will, they have the option to say, no, we don't want to take this on. We'll do the 3 months and we're not going to court to apply to be permanent guardians.
They know my children, okay. No, they are adorable, but I did not realize that. The other thing too is people are under the impression that you always have to have a lawyer to do a will. And there was a time when I was working with folks who felt they had nothing. I would say, take a pen and a piece of paper, date it, write out what is important and what you want to leave behind and to whom, and then sign it, date it, and put it in a safe place. Now, correct me for all those misinformations I was giving along.
You were not giving misinformation. You were giving correct information that it is legal in the province of Ontario for someone to sit down, handwrite a will completely in their own handwriting, sign and date it. That is a legal will in the province of Ontario. As long as you haven't written something in there that's a problem, with the law and you've sat down and you've written out a will completely in your own handwriting, that's the catch, is that as soon as you type a word in a will, you need 2 witnesses to your signature. But if it's completely handwritten in your handwriting, signed and dated, as long as the content is fine, the format is a legal will in Ontario. The technical term for it is a holograph will.
Yeah. Now, is there any language that is very specific that has to be in it? I hear I am of sound mind and body or something like that, or does there have to be a legal term that needs to be included?
Key wording to have in a will that you sit down and write out yourself is that you are intending this to be your last will and testament.
Okay.
That it is clear that you intend for these instructions to be followed when you die. If someone sits down and just writes out, I want my daughter to have all of my jewelry, we don't know if that was intended while they were alive or was it intended after they died. So it's very important to be clear when you write out your own will that you are intending this to happen when you die.
Does this supersede a previous will that may have been done through a lawyer?
It does if you write the words that you are canceling or revoking any previous wills that you have done. It's very important if you want to change your will to write those words in the new will. If you don't say that you're canceling or revoking the previous will, then the court has to try to figure out what pieces of this will apply and what pieces of that will apply.
Okay. And of course, that can just take years to sort out all those details.
It can. If people end up going to court because something's unclear in a will, or because people are fighting about what they should or shouldn't have had in the will, or fighting about whether the person was capable to make a will at the time they wrote a will, these court battles usually take years to sort out, and in all that time, the person's estate is often sitting in limbo.
Now, if you assign a power of attorney, does that help to facilitate the process?
Powers of attorney only have authority while someone is still alive. As soon as someone dies, a power of attorney ceases and the will takes over. And so once someone has died, the person who has been named to implement the will, that person is called an executor or an estate trustee. They take over being in charge of everything that happens after that. If you have a power of attorney while you're alive, the power of attorney does not have authority to make a will for you. There are 2 types of powers of attorney in Ontario law. One of them is a power of attorney for property. That deals with anything related to money and possessions. Then there's a power of attorney for personal care, which covers 6 different aspects of someone's physical well-being. In law, in Ontario, someone who is a power of attorney for property can manage any aspect of an individual's property when they've been named as the person who's supposed to be in charge of the property, except make a will. That is the one thing Ontario law does not allow a power of attorney for property to do.
Okay. So it's important, even if you feel that you don't have a lot, or you don't feel that you're leaving anything. I mean, we always said to my parents, the money is yours. Go and spend it. It doesn't have to come to us. You've earned it. But there are other families who are waiting for that sum of money at the end of life to come their way. But at the same time, the power of attorney who has control over the property also has to take into consideration the health and well-being of the parent if that is declining, as well as if you have other family members that who feel that there should be a share in that.
Yes, there is a connection between powers of attorney for property and wills in Ontario law. The connection is that the power of attorney for property can't ignore the will when they are managing the individual's property. So for example, if the will says that the individual is leaving their house to a particular family member, the power of attorney for property is responsible for trying to maintain that house until the person dies, even if the person can't live there anymore, as long as the person has enough money to pay for where they need to live well and maintain that house. So if there's not enough money to look after the person where they're living and keep the house, then the power of attorney can sell the house to have money to look after the individual. But if there's enough money to keep the house intact and look after the person where they need to live well, the power of attorney for property is supposed to do both.
Okay. And that the power of attorney is different from the executor.
Yes. So sometimes people will name the same individual to be their power of attorney for property and their executor, because when you're trying to pick someone to do those roles, you want someone who's good with money and good with paperwork. So it makes sense that you would say, I've got one person in my life who's really good with money and paperwork, so I'm going to have them do both of the money and paperwork roles for me. Power of attorney for property and executor. But they don't have to be the same person. It can make it easier for the executor to settle the estate if they've been the power of attorney for property, because they already know all of the information about your finances and your assets, because they've been potentially helping you with managing those things while you're still alive. And then they just transition to putting together all of the assets to hand over to the beneficiaries once the person dies. But you absolutely don't have to name the same individual to do both roles.
The same person makes it seamless, so it just
does.
It's more of a seamless transition.
It is.
But one of the pieces of information I picked up from your seminar, which I was so glad that I attended, and I know that you're having more at the library too, was that the executor, if they don't feel confident in that role, they have the option of handing it off. And how do they do that?
Yes, it's easiest to hand off the role before they start doing anything to take on the role. So when the individual who wrote the will dies, if the executor says right away, I don't want to do the executor role, then it's simple. They just say, I don't want to do that role, and that's it. They're out of it. However, if they get started on the executor role, so they start opening an estate bank account, they start pulling in assets to the bank account and liquidating assets that need to be converted to cash. If they start doing the work, they can only then step out if they go to court and say, please court, I've decided this job isn't for me, let me out of this.
And that could be for health reasons, or that could be you're transferred halfway around the world for your employment, or there are other factors happening in your life that have been very complicated, and you're having to deal with that as well. So there's many reasons for that.
There are, absolutely. And you bring up a point that I make to people in conversation all the time, which is that life happens. You just never know what life is going to bring. Young people say to me, I don't need a will. That's for old people who are going to die soon. And I say, you never know. You could walk out of this conversation with me and get hit by a vehicle. And then you are sorry you didn't have a will or a power of attorney.
Well, exactly, because The point that you brought up, it's only for old people. It's not. It's because you care about your family and you want to make sure that they're looked after if anything happens to you.
Yes, and that is the major reason to do a will, is to make sure that your affairs are in order when you die and to make everything easier for the people you love. You mentioned earlier about the importance of naming a guardian for your children in your will. Even if you don't have children and you don't have a lot of money or a lot of possessions, it's still important to have a will for two reasons. One of them is it ensures that it's clear who is in charge when you die. When you write a will, you name an executor, and then it's clear who's supposed to go into your apartment and clean it out after you've died. It's clear what the executor is supposed to do with your possessions in your apartment, what's to happen with your clothing that you leave behind. Whatever it is you have, it's very clear who's in charge of it and what they're supposed to do with it. I've seen some situations that people die, they don't have a will, and it's just chaos. Different family members show up and just start grabbing possessions out of the individual's apartment, and there's all kinds of fighting because it's not clear who's in charge and who is supposed to get what. So you want to have a will so that your affairs are not in chaos when you die.
So wills should start when you start to become independent from your parents as young people starting out. And not so much because you're intending to die. It's never about you. It's always about what you are leaving behind. So it's not about you.
It's not.
But then you get into the habit as your life changes to update your will, to make sure that it's current in terms of your situation now. Because we have redone our wills basically the same as we've grown along in years and our family has grown. But at one point, we didn't have grandchildren written in our will. Now we do. So I think that, but it gets you into the habit of thinking about that and putting it together. My biggest concern, as you were talking about some of the stories, is the chaos and the burden.
Yes.
Those are the last memories that people have of you.
Absolutely. And it is so hard when you're grieving someone you love and having things in order so you don't get that chaos that I described makes it easier for people to go through the grief process because they know that there's a sequence of events that needs to be followed. When you don't have a will, as I said, it's not clear who's in charge. Someone needs to go to court to get authority to handle what you've left behind. If you've got any amount of money or possessions left, technically there's no one with authority to deal with them unless someone goes to court. And dealing with all of that extra stress of court paperwork and having to deal more with lawyers is something that you don't want people you care about to endure. The other thing that you don't want to have happen that could happen if you don't do a will is that there will be people who are left out that you wanted to have something. And the example you gave of grandchildren is an excellent example because if you don't have a will, then the law has a formula for who receives your money and your possessions when you die, and grandchildren are well down the list. So if you want to ensure your grandchildren get something from you when you've died and they have that positive memory, wow, grandma and grandpa thought I was so important that they left me something in their will, then you want to for sure write a will that does leave something to them. It helps build on that comment you made earlier that your will can be a love letter to your family. Just remembering your grandchildren and leaving them even something very small in your will can make a really big impression.
Well, I'm very grateful to my grandparents, where I got some pieces of jewelry that are very important to me. But the other thing too is when you mention who's left out, if the will was made years ago when you were married and you are no longer married, but you have a new common law partner, that was interesting.
Yes, a lot of people do not realize that if you have a common law partner and you don't make a will, your common law partner has no entitlement to your money or possessions when you die, unless you had something in joint ownership with the common law spouse. So say you have everything in ownership of your own name, you have a common law spouse, your common law spouse gets nothing when you die.
If you're not formally divorced, it just all goes to the legal wife.
Yes,
That really, I thought, oh my gosh.
Yes, you are mentioning a story I told when I was speaking at the library about someone who had separated from their spouse 30 years ago, and they had a common law partner for a number of years, didn't make a will because of the timing of the separation and the fact they were never formally divorced. The spouse, the married spouse, got everything. The common law partner got nothing.
Now, if you even, so you have to update your will. You can leave out the wife, mention the common law partner by name, and then it will go to them. It will go to the common law partner.
Yes. What will happen is you write your will and you say you want everything to go to your common law partner. If you are still legally married, depending on the circumstances of the separation, the married spouse won't be able to make a claim in court to part of your estate. However, depending on the details, it's actually possible your married spouse could be able to go to court and say, I should have gotten something in the will, so give me my entitlement.
Oh my gosh.
Yes, so this is why I'm saying a will, yes, is a way of expressing love to your family, but it's also a technical legal document. And if your relationships are complicated, it's really important to get legal advice and information before you sit down and write your own will, so that you don't write something up that you think has set up all the people you love to be well looked after, just to have chaos happen because there was something in the law you didn't know.
Exactly. Have lived through that unintentionally.
Yeah.
And, you know, and it does cause hard feelings at a time, but everyone has to get over that. But this is really fascinating. I am really hoping that we can book another date, because this is only one small piece of the law. And I know that you're doing a series of lectures down at the library, and I think you have more to tell me and to the viewers. And I am hoping, thank you very much for coming today, and join me next time over coffee.
This program is brought to you by Rogers Xfinity, connecting you to more of what you love. Visit Rogers.com for more details. Connect with us by visiting our website or email us at comments@rogerstv.com.
For 25 years, you've been helping to make our roads safer by doing the right thing. You've been the designated driver, you've stayed over, called home, you've called a cab or a friend, and planned ahead. Let's keep doing the right thing. Support sober driving by getting yourself and your friends home safely.
Do the right thing.
Visit ArriveAlive.org to find out more. Arrive Alive. Drive sober.
In para hockey, the ice tilts in favor